Imagine a world where justice was as unpredictable as a rigged die rolled by a drunken gambler, where laws bent to the whims of a hungover feudal lord, a cleric with more power than common sense, or a mob of townsfolk itching for a free spectacle. The Middle Ages, that sprawling historical chapter stretching from the fall of the Roman Empire in the 5th century to the Renaissance in the 15th, was an era of majestic castles rising like stone giants, knights in gleaming, until they rusted, armor, and a sense of legality that would make us today grab our phones, call the most expensive lawyer we know, and probably move to another continent. While medieval life had its charm, think feasts with roasted boar served on wooden platters, justs where knights traded blows for honor or to impress a lady, and troubadours singing off-key ballads of impossible love. It was also packed with practices that, if tried today, would land you in jail, handcuffs included, with a cellmate who hopefully doesn't sing opera at midnight or sport a collection of questionable tattoos. Let's dive into 10 of these medieval customs that, while as common back then as ordering a mug of mead at the local tavern, would now have you facing a judge with a look of, "Did you really think this wouldn't have consequences?" Brace yourself, because some of these stories are so absurd they seem ripped from a medieval comedy written by someone with too much imagination, yet so dark they'll make you grateful to live in the 21st century, with plumbing, human rights, and a justice system that, in theory, doesn't hinge on whether a red-hot iron bar is on your side. Let's start with trial by ordeal, a judicial method that turned courts into a macabre circus, more akin to a gladiator show than a rational process based on evidence. If someone accused you of a crime, anything from stealing a chicken to poisoning the village well, cursing the blacksmith, or just giving the baker a dirty look, don't expect a trial with a jury, forensic evidence, a defense attorney with a briefcase full of compelling arguments, or even a scale to weigh the evidence. In the Middle Ages, justice was often left to God, which sounds spiritual until you learn it involved things like the ordeal by fire. In this test, they handed you a red-hot iron bar, so scorching you could fry an egg just by holding it close or, on a bad day, melt your pride along with the skin on your hands. Your task was to grip it with bare hands and walk exactly 9 steps, trying not to scream too loudly in front of a crowd gathered not so much to judge you as to enjoy the drama, like a medieval version of a reality show. Afterward, they'd bandage your wounds, or what was left of your hands, and wait 3 days. If, by some medical miracle defying the laws of biology, your burns healed without infection, you were declared innocent, because clearly God had stepped in to save you. If not, prepare for the stake, exile, or something equally unappealing, like banishment to a swamp where the mosquitoes were bigger than the chickens. The logic was that God would always protect the righteous, but in practice, most ended up with third-degree burns, a guilty verdict, and serious doubts about whether God was paying attention or just taking the day off. Today, attempting this would be considered outright torture, a serious crime under any modern penal code, from Spain's to Anglo-Saxon law. A judge proposing to burn someone to test their innocence would be arrested for aggravated assault, attempted murder, or abuse of authority, and probably end up on a late-night talk show explaining why they thought reverting to the 13th century was a good idea. And if you, in a fit of medieval nostalgia, tried experimenting with a hot iron bar in your backyard, the only miracle you'd see is the hospital bill, followed by a police visit and possible charges for self-harm, public disturbance, or, at best, a warning for doing weird stuff in the neighborhood. Plus, modern laws like the UN Convention Against Torture ban any practice causing intentional physical suffering, and burning someone to prove innocence falls squarely in that category. Not to mention violating every workplace health and safety regulation if attempted in an official setting. But fire wasn't the only star of the ordeal show. There was also the ordeal by hot water, an equally charming variant that tested your pain tolerance, faith in miracles, and ability not to faint in front of an expectant crowd. Here, you'd plunge your hand into a cauldron of boiling water, hot enough to cook a stew for the whole village or at least brew a very expensive tea. Your task was to retrieve a stone from the bottom, requiring you to submerge your arm up to the elbow in liquid hell that probably smelled like stale soup. Then, like the fire ordeal, they'd bandage your wounds and wait 3 days to see if they healed. If they did, you were innocent, and everyone applauded divine intervention. If not, tough luck, because God apparently decided you weren't worthy of his help, and a worse punishment likely awaited. This was especially common for minor crimes, like petty theft, neighborly disputes, or accusations of lying under oath, and was conducted with a solemnity that today would seem laughable, with clerics and judges watching as if evaluating a divine science experiment. In some cases, like in 9th century France, the ordeal by hot water was overseen by a priest who blessed the cauldron, as if a splash of holy water could make the process less painful. Imagine a modern cop saying, "Sir, to prove you didn't steal that phone, stick your hand in this boiling pot and grab this coin." That's a lawsuit for grievous bodily harm before the water even starts simmering, not to mention that the cop, judge, and probably the guy who heated the pot would face serious legal trouble. Modern laws, from the Universal Declaration of Human Rights to national penal codes, explicitly ban any form of torture or inhumane treatment, and this practice would violate all of them, plus several health and safety regulations. The nearest hospital would also be very curious about why you showed up with an arm resembling a grilled steak, and the staff would likely call the authorities to report a case of abuse. And if you thought that was extreme, wait until you hear about the ordeal by cold water, a practice especially popular for those accused of witchcraft or heresy, taking cruelty to a level bordering on sadism. The idea was brutally simple. They'd tie your hands and feet, like a package ready for express delivery, and toss you into a freezing river or lake, often in the dead of winter for extra drama. If you floated, you were guilty, because pure, supposedly blessed water rejected sinners, as if the river had a celestial VIP list that only admitted the righteous. If you sank, you were innocent, though probably also dead, because no one bothered too much to fish you out in time, and hypothermia isn't exactly known for its hospitality. This practice was particularly cruel because there was no way to win. Either you floated and were condemned to the stake for witchcraft, or you drowned and, well, at least you died with a clean conscience, though that wasn't much help at the bottom of the river. In some cases, judges allowed a priest to bless the water, lending a veneer of sanctity to what was essentially a human sacrifice. In regions like 13th century France or England, this ordeal was reserved for witchcraft cases, often fueled by absurd rumors, like someone hexing a neighbor's cows to stop giving milk or causing a storm with a strange dance. In 1210, a woman in Germany was thrown into the Rhine for allegedly causing a drought, and when she floated, she was burned alive. Today, tossing someone into a river to test their innocence would be considered murder or, at minimum, gross negligence. Imagine the police report, "The suspect sank, Your Honor, so they were innocent, but now we have a bigger problem because they're not breathing." Modern laws protect the right to life and prohibit any practice that endangers someone under the guise of justice. Trying to justify this with "God willed it" wouldn't save you from a manslaughter charge, and you'd likely face additional counts of abuse of authority if you organized the watery spectacle. The European Convention on Human Rights, for example, clearly states that no one can be subjected to cruel or degrading treatment, and a forced dip in an icy river definitely qualifies. Let's move away from ordeals for a moment and turn to another pillar of medieval justice: judicial duels, a practice blending violence, spectacle, and blind faith that God always backed the winning team, like a celestial referee with a divine whistle. If you had a dispute, say, over land, an unpaid debt, a treason accusation, or even a tavern insult, you could settle it in a fight to the death, or at least until one of you was too battered to keep swinging a sword. These duels were legal, organized, and often overseen by local authorities or even the church, which saw them as a way to let God decide who was right, a convenient way to dodge responsibility. Weapons varied by region, era, and the contender's status. Long swords for nobles who fancied themselves epic heroes, clubs or maces for commoners who couldn't afford an armory, and sometimes spears or axes if things got particularly cinematic. The logic was that the righteous would always win, conveniently ignoring that the stronger, faster, better trained, or just better rested fighter usually took the victory. In some cases, if a contender couldn't fight, say, a woman, a sick person, an elder, or someone who didn't know a sword from a soup ladle, they could hire a champion, a sort of dueling mercenary who fought on their behalf for money, land, or just the glory of smashing someone's face. These champions were sometimes wandering knights or professional fighters who made a living settling disputes with swordplay, like the influencers of their day, but with fewer selfies and more scars. In 1127, in Flanders, A judicial duel over a land dispute ended with a hired champion winning after breaking his opponent's leg with a mace. Imagine this in the 21st century. Hey, Juan, you owe me $50, so meet me at the park with swords at dawn. If you can't make it, send your gym bro cousin. You'd end up in jail for attempted murder or assault with a deadly weapon, plus a psychiatric evaluation and probably a few headlines like, "Man tries to settle debt with medieval duel in City Park." Modern laws prefer resolving disputes with contracts, mediators, or, at worst, a civil trial that's boring but doesn't end in bloodshed. The sword stays in museums, and trying to solve problems with violence in a legal context would violate not just penal codes but basic social norms. Hiring someone to fight for you would also be conspiracy to commit a crime, landing both you and your champion in serious legal trouble, likely with a warning to stay away from Renaissance fairs forever. Now, let's shift to something more earthy and, frankly, far smellier: medieval waste management, or rather, the complete lack of anything resembling sanitation. In medieval cities, the concept of sewage systems was as distant as a rocket to Mars or a stable Wi-Fi connection. People had no modern toilets, pipes, or garbage collection. So waste, yes, everything from food scraps to human excrement and things you'd rather not imagine, ended up in the streets, turning cities into an olfactory minefield. At best, someone might yell, "Gardeloo," before dumping a bucket out the window, giving passers-by a slim chance to dodge the liquid projectile, though the warning often came too late or not at all. Streets in cities like London, Paris, or Florence were a cocktail of garbage, manure, sewage, and who knows what else, creating a stench you could probably smell from the next village. In some cities, like 13th century London, streets were so narrow and waste so abundant that walking without ruining your shoes was a feat worthy of a knight on a heroic quest. Pigs, often roaming freely, acted as natural cleaners, eating organic waste, which wasn't exactly hygienic since they added their own contributions to the mess, creating a filth cycle that would make any modern health inspector faint. In some regions, like parts of Germany or France, fines were introduced to curb this, but they were so low that people kept tossing buckets out windows without much guilt, like it was part of their morning routine. In 14th century Paris, authorities tried mandating waste disposal in specific spots, but lack of infrastructure and general apathy kept the streets a disaster. Try that today, and you'd face fines for environmental pollution, municipal ordinance violations, and, depending on severity, charges for endangering public health. In many countries, improper waste disposal is a crime carrying hefty fines or even community service, like cleaning the streets you dirted. In the UK, littering in public can cost up to £2,500, and for extreme cases like dumping hazardous waste, you could face up to 7 years in prison. And if you insist on yelling, "Gardeloo," while tossing food scraps at your neighbor, you might also be charged with public disturbance or even assault if someone ends up soaked in stale soup. Modern cities, with their sewage systems, garbage trucks, and littering fines, remind us how far we've come, though some people still toss diapers out windows or leave trash on the sidewalk, making you question human progress. Back to justice, but with a crueler, more theatrical twist: public physical punishment, a practice that made penalties both a sentence and a spectacle worthy of a Roman amphitheater. In the Middle Ages, for minor crimes like stealing bread, insulting a feudal lord, defaulting on a debt, or, on a bad day, tripping over the mayor's wife, you could end up in the stocks, a wooden contraption that locked your hands and head while townsfolk had fun pelting you with rotten vegetables, manure, or, on a particularly creative day, stones or dead fish. The goal wasn't just to punish but to publicly humiliate you, making you a human billboard screaming, "Don't do this, or you'll end up here." In some cities, like 12th century England, stocks were strategically placed in the main square, and people gathered like it was a fair, bringing their own projectiles for the occasion, from spoiled tomatoes to things you don't want to picture. Other punishments included public whippings, where you'd be tied to a post and lashed before a crowd that sometimes bet on how long you'd last before fainting. For graver offenses, like repeat theft or forgery, you could lose a hand, an ear, or be branded with a hot iron marking your crime, like a T for thief or an F for forger, ensuring you carried your shame on your skin forever. These punishments were legal, backed by feudal law, and often cheered by crowds who saw them as justice, entertainment, and a chance to vent their own frustrations. In 1290, in London, a baker who sold underweight bread was put in the stocks with a sign explaining his crime, while passers-by threw his own stale loaves at him. Today, any public physical punishment would violate laws against cruelty, torture, and inhumane treatment. If a modern judge tried sentencing someone to a day in the stocks or a public whipping, they'd be charged with abuse of authority and likely fired before they could grab the whip. International conventions like the Geneva Conventions and national penal codes explicitly ban punishments that degrade human dignity. The spectacle of public humiliation would also violate fundamental rights, and the perpetrator could face civil and criminal lawsuits. Thankfully, we now settle things with fines, prison, or, at worst, a lecture from a bored judge that makes you wish for the stocks just for a change of scenery. In Spain, for instance, physical punishment would violate Article 15 of the Constitution, which bans inhumane or degrading treatment, and the responsible party could face up to 3 years in prison for assault or abuse. Now, brace for something that sounds like comedy but was deadly serious and, in hindsight, profoundly absurd. Animal trials, a practice that pushes medieval justice into surrealism that would make Salvador Dali blush. In the Middle Ages, not only humans could end up in court. Pigs, cows, rats, dogs, cats, and even insects could be tried for crimes, as if they were citizens with full criminal intent and a malicious agenda. If a pig ate a neighbor's corn, ruined a garden, or, in an extreme case, attacked someone, it could face a trial with all the formalities. A judge, witnesses, a defense attorney for the animal, and even an official verdict written on parchment. In 1457, in Savigny, France, a sow and her 6 piglets were tried for killing a child. The sow was sentenced to the gallows, executed publicly in the town square, while the piglets were acquitted for being minors and, supposedly, lacking their mother's criminal intent. The trial included witnesses testifying about the pig's character, a lawyer arguing she acted on instinct, and a verdict written with the same gravity as if it were a human murderer. It gets weirder. Entire pest infestations, like locusts, rats, or moles, were tried for destroying crops or causing havoc. In 1519, in Stelvio, Italy, a group of moles was tried for ruining crops, and their assigned lawyer argued they were God's creatures with a right to eat. The judge, unconvinced, gave them weeks to leave town under threat of excommunication, as if moles could read the edict and pack their bags. In 1474, in Basel, a rooster was tried for laying an egg, deemed unnatural and possibly demonic, and burned at the stake after a full trial. Imagine trying this today. Your Honor, this cat stole my salmon from the fridge. I want it sentenced to life. You'd likely be charged with animal cruelty or causing an unnecessary public spectacle, and the judge would look at you like you'd lost your mind. Executing an animal for a crime would violate animal welfare laws in most countries, which recognize animals as living beings incapable of criminal intent. In the UK, the Animal Welfare Act 2006 imposes up to 7 years in prison for cruelty, and in Spain, the Penal Code punishes animal mistreatment with up to a year in jail. Trying to excommunicate a cockroach infestation would get you a referral to an exterminator, not a lawyer, and maybe a mental health evaluation just in case. Another practice that would land you in serious trouble today is poaching on noble lands, an act that in the Middle Ages could cost you far more than a fine or a scolding from a ranger. Forests, rivers, lakes, and lands belonged to feudal lords or the king, and hunting or fishing without permission was a grave crime, akin to stealing straight from the noble's pocket. If caught hunting a deer in the king's forest or fishing a salmon from his river, you could lose a hand, an eye, an ear, or even your life, depending on the lord's mood, the animal's value, or whether they wanted to make an example. In England, under the Normans forest laws in the 11th century, poaching in a royal forest could lead to punishments like blinding or castration, designed to deter peasants from touching the crown's resources, who saw deer and pheasants as their personal property. In 1087, an English peasant was blinded for hunting a rabbit in a royal forest, a punishment that today seems not just cruel but absurdly disproportionate. These laws protected noble privilege but were brutally unfair to peasants, who often relied on hunting to survive in times of scarcity. Today, poaching is still illegal, but penalties are far more reasonable. Fines, equipment confiscation, or, in severe cases, up to 7 years in prison in places like the UK for crimes against protected species, like hunting elephants or rhinos. Inflicting punishments like mutilation or execution for poaching would be considered cruelty and abuse of power, violating fundamental human rights, including the right to a fair trial and proportionate penalties. In Spain, poaching can carry fines up to €100,000 in serious cases, but no one's going to chop off your hand for fishing a trout without a license. Modern property rights over land are also less absolute, and laws recognize that natural resources aren't the private domain of a crowned lord. If you tried punishing someone with mutilation for hunting on your land, you'd face charges for grievous bodily harm or attempted murder, and you'd likely end up in court explaining why you thought you were the next King Arthur. Let's move to a murkier but no less fascinating topic: the sale of indulgences, a business that made the medieval church look like a spiritual marketing firm with a revenue model worthy of a modern pyramid scheme scammer. If you sinned, whether lying, stealing, committing adultery, gossiping about the bishop, or something juicier, you could buy an indulgence, a document that supposedly reduced your time in purgatory or even absolved you entirely, as if God had a celestial cash register. It was like a VIP pass to heaven, but the price depended on your wealth, the severity of your sins, and the ambition of the cleric selling it, often acting like a peddler in a cassock. Some indulgence sellers, like the infamous Johann Tetzel in the 15th century, roamed towns with catchy slogans like, "As soon as the coin in the coffer rings, the soul from purgatory springs," convincing people they could buy salvation like a lottery ticket. In some cases, indulgences were sold for future sins, like a coupon to sin without consequences. A sin now, pay later deal that was as lucrative as it was morally dubious. This business was especially profitable during the Crusades, when the Church needed funds for holy wars and offered indulgences for generous donations, turning faith into a commercial transaction. In 1198, Pope Innocent III promoted indulgence sales to fund the Fourth Crusade, with the faithful paying exorbitant sums for a promised shortcut to paradise. Today, this would be considered fraud, religious scams, or even extortion. If you tried selling divine pardons on the street, you'd be charged with deception or, if the operation grew, money laundering. Modern laws ban profiting from false spiritual promises, and selling indulgences would violate everything from penal codes to consumer protection laws. Imagine a social media ad: "Pay now, secure your spot in heaven. Discounts for minor sins. Offer valid until Judgment Day." You wouldn't last a day before your account was shut down, you were fined, and likely investigated for organized fraud. In Spain, religious scams can carry up to 7 years in prison if intentional deception is proven, and in countries like the US, you could face charges under fraud laws like the Foreign Corrupt Practices Act if the scheme crossed borders. Plus, the tax authorities would be very curious about where those celestial profits came from. Another dark medieval practice, one that would land you in epic legal trouble today, was forced marriage, a custom so common it was rarely questioned but now considered a gross violation of human rights. Weddings weren't always about love. They were often arranged by families to seal political, economic, or territorial alliances, like people were pawns on a feudal chessboard. Brides, sometimes as young as 12 or 13, rarely had a say, and grooms weren't always in a better position, especially if they were from lower classes and their families depended on the union to survive. Among nobles, marriages could unite dynasties, avert wars, or secure inheritances, while for peasants, they were often about securing a dowry, a plot of land, or an extra pair of hands for the fields. Refusing to marry could lead to physical punishment like beatings or confinement, disinheritance, or social ostracism, which in such a closed society was almost a death sentence. Child marriages were especially common among the upper classes, where girls as young as 12 could be betrothed to much older men to secure alliances. In 1328, Margaret of Burgundy, aged 13, was married to Louis of Flanders, 24, to seal a political alliance, with no one asking her opinion. Today, forcing someone to marry would violate laws against coercion, child marriage, and human trafficking. Consent is a non-negotiable requirement for legal unions in most countries, and forcing marriage can lead to charges ranging from kidnapping to child abuse. In the UK, Forced marriage has been a specific crime since 2014, with up to 7 years in prison, and in Spain, the Penal Code punishes coercion with up to 3 years, with harsher penalties if minors are involved. Laws protecting children and human rights have made "marry this guy or you're disinherited" not just unacceptable but illegal. Thankfully, you can now choose your partner, or at least try, without a feudal lord forcing you to wed his distant cousin who smells like a stable and has an obsession with catapults. Finally, but no less significant, is the burning of witches, a practice that, while peaking in the 16th and 17th centuries, was already common in certain medieval contexts, especially toward the end of the Middle Ages as paranoia about witchcraft grew like a plague. Accusations of witchcraft could target anyone, but especially women who stood out for their independence, knowledge, unusual behavior, or simply for owning a black cat, having a wart, or predicting the weather. Witches faced brutal interrogations, often under torture, to extract confessions, and many were burned alive at the stake, hanged, or executed in equally cruel ways. Charges could be as absurd as knowing medicinal herbs, having a suspicious birthmark, talking to animals, or just rubbing someone the wrong way. In 1390, in Paris, a woman named Jeanne de Brigue was burned for allegedly using magic to heal illnesses, something we'd now recognize as herbal medicine or, at worst, a well-meaning placebo. Witch trials often lacked real evidence, relying on rumors, fear, superstition, and, in many cases, personal grudges. If a neighbor didn't like you, you could be branded a witch for cursing their cow or causing a storm with an odd dance. In some cases, ecclesiastical and secular courts collaborated, creating a system where church and state united to persecute the guilty. In 1431, Joan of Arc was accused of witchcraft, among other things, and burned alive, though her case also had political motives. Today, accusing someone of witchcraft and acting on it would be considered murder, torture, or persecution. Modern laws protect religious freedom and ban violence based on beliefs or superstitions. If you tried accusing your neighbor of witchcraft and setting them ablaze, you'd not only go to prison for murder but likely star in a documentary about absurd crimes titled "The Case of the Neighborhood Witch." Defamation laws would also land you in trouble for baseless accusations. In Spain, defamation can lead to fines or even prison if it causes serious harm, and in the UK, libel laws are equally strict. These 10 practices, ordeals by fire, hot water, and cold water, judicial duels, garde-à-vous waste disposal, public physical punishments, animal trials, poaching on noble lands, selling indulgences, forced marriages, and witch burnings, were as normal in the Middle Ages as paying taxes, arguing on social media, complaining about traffic, or waiting 20 minutes for coffee at a crowded cafe is today. But if you tried them now, you'd face a legal system that, thankfully, values logic, evidence, and fundamental rights over superstition, arbitrary power, or blind faith that God will sort it out with a wink from heaven. Each practice, in its context, reflected a worldview where justice, hygiene, and human rights were more optional than choosing between mead or beer at the tavern. The ordeal by fire, for example, wasn't just a test of innocence but a way to reinforce the Church's authority as God's intermediary, often charging a fee to oversee the process. Judicial duels channeled violence in a society where weapons were as common as shoes, and physical strength often determined right, regardless of truth. The lack of sewage reflected primitive urban infrastructure, where daily survival left little room to care about street cleanliness or smells. Public punishment served both to penalize and entertain in an era without Netflix but plenty of appetite for watching someone suffer, especially if they owed you money. Animal trials, though absurd, show how the medieval mindset sought supernatural explanations for earthly problems, like a locust plague or a hungry pig eating a garden. Poaching laws reminded peasants of the feudal hierarchy, where natural resources belonged to a few, even if the poor starved. Indulgences blended faith, greed, and cynicism, exploiting fear of the afterlife to fill church coffers. Forced marriages reflected a society where individuals mattered less than family, clan, or politics, and consent was a luxury few could afford. Witch burning stemmed from a toxic mix of fear, ignorance, misogyny, and fanaticism, turning independent women, or just those in the wrong place at the wrong time, into scapegoats for communal problems. Today, thanks to centuries of progress, These practices seem not just barbaric but profoundly unjust, like someone wrote medieval laws after a night of mead and bad decisions. The Middle Ages had their charm, with towering castles, knights in armor heavier than a small car, epic tales of dragons and heroes, and feasts where food was as plentiful as the fights. But it was also a place where logic often took a long vacation, leaving behind a trail of pyres, flying buckets of waste, pigs in the dock, and women burned for knowing too much about herbs. If you tried tossing trash out your window, burning someone to test their innocence, fighting a duel to settle a debt, trying a cat for stealing your dinner, hunting a deer without a permit, selling indulgences on eBay, forcing someone to marry, or accusing your neighbor of witchcraft, you'd face a legal system that, while not perfect, at least tries to rely on reason, evidence, and respect for human rights. Modern laws, from penal codes to international treaties like the Universal Declaration of Human Rights, are designed to protect life, dignity, and freedom, things that in the Middle Ages were more a suggestion than a reality. So the next time you grumble about a traffic fine, a lengthy trial, a water bill, or a neighbor blasting music too loud, remember, at least you're not being forced to walk with a red-hot iron, fight a sword duel, dodge flying buckets of waste, defend a pig in court, pay for your salvation, marry a stranger, or prove you're not a witch while sinking in an icy river. Living in the 21st century has its issues, but at least you don't have to worry about being judged by a river, excommunicated by a rat, mutilated for fishing a trout, or burned for knowing too much about medicinal plants. And if you ever feel nostalgic for the Middle Ages, stick to the feasts, armor, and knightly tales, and leave the ordeals, waste buckets, and pig trials to the history books where they belong.